Welcome back to Breaking Down the Brief. I'm Allison, a current internet issue voter. This August, as Congress is in recess, we're providing 3-minute, nonpartisan, accessible explanations of recent Supreme Court decisions. For Day 4, we are considering the case City and County of San Francisco v. Environmental Protection Agency decided on March 4, 2025 concerning the scope of regulatory authority over water quality standards. San Francisco's sewer system simultaneously collects sewage and stormwater runoff in the city. The combined sewer overflows, CSOs, get discharged into the Pacific Ocean. The Clean Water Act, CWA, and 1972 federal law establishing water quality standards generally does not allow discharge of pollutants from a point source into navigable waters. If this occurs, such as from San Francisco sewage into the Pacific Ocean, it must be authorized by a permit under the National Pollutant Discharge Elimination System. The Environmental Protection Agency, EPA, established in 1970 and tasked with protecting human health and the environment, issues these permits. In 2019, the EPA issued a new permit for a San Francisco water treatment facility, articulating a violation of water quality standards and mandating that the city make alterations. Instead of focusing on the CSOs or quality of the water being discharged, however, the permit held San Francisco accountable for the end results, or the water quality of the Pacific Ocean where the discharge was being received. San Francisco argued that these end results requirements were inconsistent with the CWA and EPA regulations. The EPA's Environmental Appeals Board denied San Francisco's administrative appeal. The U.S. Court of Appeals for the Ninth Circuit denied San Francisco's petition for review, holding that the NPDES permit was valid. The Supreme Court considered the following question: did the Clean Water Act allow the Environmental Protection Agency to issue this permit? In a 5-4 decision, the Supreme Court reversed, holding that no, this permit is not allowed. Under Section 301 of the CWA, NPDES discharge permits can include 3 types of regulations: effluent limitations, water quality-based effluent limitations, and narrative requirements. These regulations focus on controlling the concentration of pollutants in water discharges and prescribing best practices for maintaining treatment site areas and equipment. The CWA does not authorize the EPA to include end result provisions in wastewater discharge permits. This decision matters because it clarified the scope of the EPA's regulatory authority under the Clean Water Act. On the one hand, this decision may result in more manageable and predictable permits, creating more straightforward requirements for cities like San Francisco to design and operate their water discharge systems. On the other hand, some are concerned that environmental protections will be weakened as the EPA has a more narrow authority to enforce CWA standards. As these legal battles continue, here are some sources for further exploration. This was Day 4 of Breaking Down the Brief with Issue Voter. Follow us to stay up to date on more Supreme Court cases. Issue Voter is a nonpartisan platform that makes civic engagement accessible, efficient, and impactful. Visit issuevoter.org to learn more. Sign up to stay up to date with legislation and make your voice heard.